Welcome and thank you.
Welcome to today's program. So, you want to be a labor and employment lawyer? What this attorney does, sponsored by the Labor and Employment Law section, the Young Lawyers section, and the Committee on Continuing Legal Education of the New York State Bar Association. Today's program will run from 12 p.m. to 1:30 p.m. And at any point, if you'd like to pose a question to today's panel, please use the chat function in your Zoom portal. And at this time, it is my pleasure to turn the program over to the moderator of today's program, Steven Sledzik, to get things started for us. Steve?
Good afternoon. Welcome and thank you for attending. I am Steve Sledzik. I'm a partner with the Morrison Law Firm here in White Plains. I am the co-chairman of the Labor and Employment Law section of the New York State Bar, its membership and engagement section. The New York State Bar has free membership for law students. The Labor and Employment section has about 1,600 members. We've got about 10 to 15 committees, some of which deal with substantive issues of law, such as workplace rights and responsibilities, equal opportunities, equal opportunity committee, wage and hour. We've got a public sector committee. We've got committees dealing with younger attorneys. We have a LinkedIn page. Some of you may have found that already. We also have a journal that's published once or twice a year dealing with substantive issues of labor and employment law. We've got a couple of programs coming up in the next little bit. On June 24th, 2024, it is the 60th anniversary of the Civil Rights Act, Title VII. We've got a presentation, a talk with John Coverdale, who is a SUNY Stony Brook professor in human resources, who's going to present on that issue. Happy birthday to Title VII. And in September, on the 27th and 28th, we've got a fall meeting at the Sagamore in Lake George. That'll be about 7 hours of CLE classes. There'll be a keynote speaker. We're trying to get someone dealing with diversity, equity, and inclusion issues related to Native American communities. There's some social events, golf, boat rides on Lake George. There are scholarships available for law students. So if you are interested, please find a way of contacting me. Last year, we had 2 college students from Cornell and 1 law student from St. John's who attended with us. Our section also has mentoring and diversity fellowship programs. We've also got 2 programs that are of, in my mind, great importance to law students. In the fall, November of 2024, we have the Samuel M. Cainard Memorial Student Service Awards. I believe that's a $5,000 award. It is for service in the labor and employment field to a law student. They are nominated by a professor or dean of their school for engagement in research or practice or clinical studies involving labor and employment. We also have the Dr. Emanuel Stein and Kenneth Stein Memorial Law Student Writing Competition. There are awards of $3,000, $2,000, and $1,000 for articles in the field of labor and employment. Your article then is published in our journal for section members. And then I'm just going to move on to the areas that we're going to cover in this. In the labor and employment field, there are essentially 4 primary areas. There's representation of management or employers. There's representation of employees. There is representation of labor or unions, and there is the alternative dispute resolution, the ADR, arbitration and mediation field. And we've got somebody from each of those 4 areas. I'm going to briefly introduce our participants because they're going to be talking about themselves today. For the field of management and employer representation, we have Tracy Rochelle High. She is a partner at Sullivan and Cromwell. She is co-head of the labor and employment group there. That is a national and international law firm with more than 800 attorneys. They're in New York, Los Angeles, Europe, Africa, Latin America. Tracy is, I dug this up on the internet. She has published a novel many, many years ago In terms of the State Bar, she is the recipient of the New York State Bar John E. Higgins Diversity Trailblazer Award winner, and that's for exceptional efforts of a member of the legal community to promote the full and equal participation of diverse people at all levels of the legal profession. It's one of the highest honors that the State Bar gives. Representing the employee side of things is Viviana Morales. She is a partner at the Peckman Law Group. I believe Vivian started as a clerk there many years ago. It is one of the preeminent employer side law firms. If you've gone on the New York Times website and have heard about some of the lawsuits involving prominent restaurants in New York City where the wait staff has perhaps been underpaid, the Peckman firm's been involved in those with seven-figure settlements in some cases. Viviana has done more than 100 individual cases, class action, collective cases. She's won a several $100,000 jury verdict, a collection action settlement of almost $1 million against an iconic New York ice cream shop, $250,000 settlement for construction workers, and more than $100,000 settlement for a group of cleaning workers who were paid below the minimum wage. Tim Taylor has worked for a law firm. He's worked for a union. He's taught at several universities. Right now, he is a full-time arbitrator and mediator with the Scheinman Arbitration and Mediation Services. It is a preeminent New York and national ADR service, and he's the former chair of our section. He's a pretty good golfer, too. And Jose Mangeras, the last member of our committee, is a attorney and labor relations attorney with the New York State United Teachers in Albany. He is in-house to unions representing employees on contractual and statutory issues. He's a Marine Corps veteran and a former law enforcement officer. And I'm going to start out with Jose. We had a chance in preparing for this, and I've known Jose probably the longest of the panelists. Jose talked a little bit about what drew him to being a union attorney. So I'm going to start with that, and then I'm going to ask him to talk about what a union attorney does, and then we'll have each of the panelists explain what they do in their field. So go ahead, Jose. You're muted.
It's undeniable that I grew up in a union household and that I have worked and continue to work in a unionized setting. But I've always had an academic interest in labor.
Yes, sir.
In my organized labor typically translates into higher wages and better working conditions, which in turn translates into spending power for your average American. And that spending power, at least in my view, has a direct impact on class mobility and our national economy. So that's what has essentially brought me to labor.
And so what do you do in representing a union? What is your area of practice like or about?
So I work with the New York State United Teachers, which is a labor organization that is affiliated with about 1,200 local unions, and we provide legal services to those local unions. For example, we operate and practice in different areas of law within labor, and also practice in different forums. For example, but the core of our work is under the education law and the different kind of cases that touch upon those statutes to include discipline. So in essence, we could find ourselves one day in an administrative hearing, and the next day we are in court doing oral argument.
And now I'm going to turn it over to Tracy Rochelle. Hi, you represent primarily management and employers. Can you explain a little bit about what that means to younger attorneys or law students?
Yes, absolutely. So nice to be here with everyone on this esteemed panel. So what I do is really defense side. And in that, I represent employers, and usually pretty large employers. So usually Fortune 500 companies who are dealing with individual issues that employees may be bringing, class action litigation that might be brought on behalf of a number of individuals who were former employees and sometimes current employees. And then also helping companies address their policies and procedures, their views on how to address certain issues. So really thinking about things from a perspective of what companies need to do in terms of making sure they're staying within the bounds of the law. And so I rarely represent individuals, although I do on some situations, if it really calls for it, in going against an employer.
Great. Thank you, Tracy. And I'm going to turn it over to Viviana. I know your firm also does represent employers, but again, it is more known for its employee work. So I'm going to let you explain a little bit about what you do.
Sure. Good afternoon, everybody. Happy to be here and talking about labor and employment law. As Stephen had said, so Peckman Law Group, we're a little bit different because we wear both hats. We do plaintiff and defense, but we will primarily do a lot of plaintiff side work. So that just means that I represent employees in all facets of labor and employment law. I concentrate mostly in discrimination and wage and hour practice. So that can really mean, all types of discrimination, included sex harassment, disability, religious accommodations, a lot of different things that you can sue for. And that could either be in federal court or with a city agency or a state agency or a federal agency that investigate discrimination cases. And on top of that, with wage and hour, those are generally brought in federal court or state court. So I'm representing employees in really all types of litigation that they could possibly be bringing. A lot of that also includes just negotiation. Not every cause of action is filed. So there's a good amount of negotiating with, somebody that's sitting in Tracy's seat, essentially. So that's really what we're doing. So a lot of litigation. We are unique that will represent both, Fortune 500 companies or individuals or, bartenders and servers at restaurants. So it is very multifaceted, a lot of different types of cause of action that you could possibly bring.
Great. Now I'm going to turn it over to Tim Taylor to talk about what alternative dispute resolution may mean. Some of you may be familiar with that term, some may not. So take it away, Tim.
Okay, I'm a full-time arbitrator and mediator, and I get to work with fabulous people most of the time, including my colleagues at Scheinman Arbitration and Mediation Services. The role of an arbitrator in labor and employment law is fascinating, right? It's to seek justice. That's actually the definition. And so when I first discovered this thing way back when, I was like, wow, that's fascinating that that's someone's job title, that arbitrators are unfettered by the rules of evidence. They seek justice. So that meant I have to spend a lot of time figuring out what the heck is justice, right? That's what we do. That's the job. The job is figuring out justice. So in that pursuit of figuring out and seeking justice, you have to have, a wide range of talent and experience, because you need knowledge and you need experience. With knowledge and experience, you have wisdom, and with wisdom, that's what people are paying for. People are paying for your wisdom, the fact that you've been an expert in your field for a long period of time. In labor cases, believe it or not, unlike other fields, you actually have to have 20 years of experience before they'll let you even serve on a labor panel. 20 years of doing this stuff, of doing the hard work of constitutional law, civil procedure, administrative law, contracts, criminal law, criminal procedure law, and evidence. You actually have to be involved in the things that Jose spoke about this morning. You have to have a wide range of knowledge in terms of collective bargaining, how that actually happens, how contracts get formed. Because when you go to court, you're defending those contracts, right? Or you're defending your interpretation of that language. You actually have to have a very foundational understanding of how contracts are formed. You have to have a firm understanding of administrative law to do my job, because you're running administrative hearings. that are subject to judicial review, right? So they have to be done in a particular way to protect the outcome. You also have to be familiar with court proceedings. A lot of the work that I do dovetails with legal proceedings, like fair legal proceedings. Whether there are we're one step before someone files in federal court a complaint, or we're tasked to be the arbitrators of huge employment discrimination cases, which are very legal. Those are legal cases that have precedent and decisions and statutes. My job is usually the high point. And so if you want that to be right, if you want that to be the high point, an arbitrator mediator is what a lot of us set out to do 20 years ago. And I always say it's kind of like planting a tree, Steve.
Yep.
It's like, when's the best time to plant a tree? 20 years ago. But if you didn't plant it 20 years ago, it's today. So a lot of us who knew we wanted to do this 20 years ago, because that's what it took to even get listed, you start with the end in mind, and you start, developing all those different pieces along the way.
And I think reading a little bit between the lines of what you say, I mean, you are a private arbitration service. You're outside of the judicial process, although what you do may become part of an enforcement action later on judicially. And Tim, also, you talked about arbitrating and doing justice, but you also mediate. Could you explain to people what that means?
Mediate is a fascinating field as well, because that requires a specific set of tools. I work with John Sands a lot when I was younger, and John would take me around, and I had done mediation at the lower levels. When you try to develop your chops, you work in hallways and basements of courthouses trying to resolve commercial disputes involving landlord, tenant, or $50 muffler job somewhere. And that stuff's important, but that's not labor, right? That's not what we're trying to do in labor. What we're trying to do in labor is mediate big disputes involving millions of dollars or millions of dollars at stake in a contract. John Sands taught me something years ago. He said, you're developing a toolbox that allows you to solve problems,
Right.
whatever they are, whatever they are.
The idea is to try to unify the parties and bring them together to work out a settlement and resolve their dispute informally.
Absolutely, because it's not my problem, it's theirs, and they have to solve it. And so you just want to be available to them to help them solve their, I don't go to mediation saying I'm the hero riding in on a white horse. That's not my job. My job is to work with the lawyers, and they're usually fantastic lawyers I get to work with, bringing them in the room and saying, let's put our heads together and figure this out.
Great. Thank you, Tim. And I'm going to ask you guys each, again, feel free to comment on what anybody else has said, because your practices are multidisciplinary at times. I know Jose has been involved with mediations and arbitrations. Tracy has, I know Viviana has, I have. But feel free to comment. I'm just going to ask you all now, just starting with Tracy, what is a typical day like for you as a labor and employment lawyer, or a week or a month? You might be on trial all month. I've got a trial coming up in a couple months. I'll be on trial for a week or two. So
yeah, it totally depends, and I'll take kind of maybe a week snapshot. I have investigations that I'm conducting, and so the pace of my day, for instance, yesterday meant that I needed to devote the substantial portion of my day with speaking with employees at an organization to get an understanding of the culture at that organization. The organization had received an anonymous complaint letter making a variety of allegations, including that the environment was a toxic workplace. So to have some understanding of what it's actually like to work within the organization, I needed to spend a substantial amount of time interviewing individual employees to get their take on what it's actually like to work in the workplace. In addition, I had a lot of correspondence with the general counsel to understand some of the things factually that I was hearing, to understand whether there was a basis for what the employees were saying, or were they operating under some sort of misimpressions? And so throughout this week, I will be spending time interviewing various employees to create a picture for myself so that when I do my reporting, I can put those who aren't in the day-to-day aspect of the business, get an understanding of this is what your people feel like it is to work here and under their various managers and supervisors. So kind of a lot of prep going into dealing with that. Then I had clients who were also yesterday, and this will continue on through the week as well, asking me questions about what to do with respect to individual employees. So those questions related to job performance. And we think this person isn't performing up to snuff, but here's the other complications that come with that. So they may be a person who's in a protected class. They may be a person who hasn't gotten what I would consider appropriate feedback on how they're performing, such that if my client wanted to take some disciplinary action, whether that person would fundamentally feel like what the employer wanted to do was fair. And then there were some other personal complications as well at play that really kind of show, I think, how exciting this field can be, because it's not just dealing with what does the law say? Okay, we go to the cases, we can analyze A, B, and C. There's also highly individualized and personalized factors here that you have to take into consideration. So the law may say that you can do one thing, but that may not be the best thing to do under the circumstances, because you also want to take into account people's human elements and how things might well be received. So I was also dealing with, in addition to kind of a large scale workplace culture investigation, questions on how to deal with individual employees. I then also this week was in California starting on Sunday because I'm dealing with a multinational corporation whose headquarters are in California, but they have some issues with some of their international operations and some pretty thorny issues with the international operations. So I went to California to go to the headquarters because I wanted to see how certain systems rolled up into headquarters systems, so that before I go overseas, I can have background information that would be helpful for me when I go to talk to employees in foreign jurisdictions about the work that they're performing. And so in the course of a given week, I will have dealt with individual issues. I would have dealt with kind of enterprise-wide issues. And then in addition to just doing kind of straight legal analysis of can you, can't you, what are the boundaries, kind of also taking into account just human elements of this person is in the middle of this. And so how should that affect that? When I'm dealing with multinational corporations and it has an international element, I also have to think about things like, do I need a translator? Do I need local counsel? So for instance, I'm a great lawyer, but I can only practice, right, within New York and the other jurisdictions where I'm licensed. And so I also had to go about getting local counsel who would help me address some of the thorny questions that may affect whether the company can go in and take people's cell phones, for instance, whether the company can go in and start reading people's emails, because the protections are different in different jurisdictions, not only here, but throughout the world. So that's a little snapshot of my week.
It's funny, my wife is a psychotherapist, and I describe the fact that dealing sometimes with the human element, like I have to do in my career, is I have a minor in psychology, which it sounds like you also have, as well as organizational psychology and probably cultural psychology. So you got a lot going on there. I'm going to turn this over. Sorry, go ahead. I'm going to turn this over to Viviana for what a week or a month in her life may look like.
Thank you. I ditto the psychology element of this. So much of this is not about the law. It's about psychology with opposing counsel or dealing with your client. For me, taking borrowing a page from Tracy's handbook, just looking back at the last few days, labor and employment is really great because you get a lot of experience in litigation. So as a plaintiff side attorney, you're in court a lot and you're in court very quickly once you join a labor and employment practice group. Like 10% of the docket in New York is just comprised of wage and hour cases. So you're able to appear before federal court judges and make these arguments and get that experience so quickly, whereas some of your colleagues might not have that experience. And particularly being in a boutique law firm, which is where I practice and have practiced my whole career, you really do get exposure very quickly. And for me, so recently we have a trial coming up. So I was just before a federal court judge yesterday in terms of talking about setting the trial schedule. Is it going to be a jury trial? Is it going to be a bench trial? How are we going to position the issues on a wage and hour case? So that involves a good amount of negotiation with the other side to figure out whether or not you can narrow some of the issues that are actually going to be decided at trial. So that took up a good amount of my time yesterday. And then with other plaintiff individual cases, we actually have a client right now that I'm helping through. She's intending to breach her employment agreement. So when you get hired at a company, you might have to sign an employment agreement, which says that once you leave the company, you are not allowed to compete with the company. So sometimes you have people coming in and say, listen, I have this great opportunity and I need to breach. I need to try to see if I can get out of this non-compete. So as a plaintiff side attorney, you are going as Timothy Joe was just describing in terms of you have to know about contract law. So you have to look through the contract. Is there any way to breach this? Is there consideration? Was there anything, any other way that this person can get out? How clear is the non-compete? So then you're looking at case law. Is there a way to get out of this? And what's really going to be that negotiation with general counsel to avoid a lawsuit? A lot of times you don't want to be in court. The client does not want to be it doesn't want to be associated with a lawsuit. So you really have to be very careful with that and careful in your negotiations with the other side to try to avoid a litigation if you can. So dealing with that sort of contract side of it. And then also, having clients preparing for depositions in cases, for sex harassment cases, those types of deposition prep are a large part of what you do when you're in litigation because the deposition is so important to both sides. So in this situation, you got an employee that's filing a sex harassment case against a city agency. So there, the city agency is allowed to take a deposition, get all their discovery essentially ahead of time. And there you really have to walk them through, well, what sort of questions are going to be asked of you? How, what's my role going to be? I'm going to be there, but there's really not much I can do, getting them for remembering the story, exactly what happened and how it went. And this is where the psychology comes into it because bringing a sex harassment case is very difficult. You're going to be talking about things that are very sensitive to someone you've never met before in a public setting. Somebody's going to be taking down all your words. It's not a natural situation. It's not anything anybody wants to be a part of. So as a plaintiff's attorney, you really have to keep that in mind, and you're essentially holding their hand, walking them through the process, making it as easy as you can for them. And then for a lot of my practice is wage and hour. So I deal with a lot of class actions. So currently we're moving through a multi-million-dollar class action where right now we are preparing all of the documents, preparing the motion practice. So a lot of your job or my job as a plaintiff's attorney is just keeping your head down and drafting papers, drafting a bunch of motions, declarations, getting orders ready so that when the court sees an agreement reach between counsel, they can approve it, and then notice would go out to the class members who can then join in the litigation. So a lot of that is dealing directly with your clients, having those discussions with them, keeping them apprised of what you're doing. A lot of my day is speaking directly with clients. I do a lot of representing individuals in these wage and hour cases or these discrimination cases. So a lot of it is just keeping them up to date on what's going on, preparing them for what to come. And then for new cases, you're doing just a lot of issue spotting. Somebody calls on the phone, and they never spoken to a lawyer before. They're just like, something's wrong at my job. I don't really know what it is. So you're sort of a law student again. You're sort of going through the whole story and picking out pieces that you think could possibly form a case later on, or give that person some kind of leverage if they want to leave their job, if you're reviewing a separation agreement, for example. So a lot of different things, you know, within litigation and also with just negotiation and, you know, every day can be a little bit different, but it all sort of falls together in terms of just keeping your clients apprised of what's been going on and moving your cases forward.
And I know what both Tracy and Viviana do, and just Tracy in describing the investigation, I know ultimately there'll be a written investigation report, which will be substantive and have some legal analysis to it. And I know what, and you preparing for that jury trial, you're submitting charges to the, potentially submitting charges or a pretrial memo of law to the judge. We do writing as well as counseling clients. With that, I'm going to turn it over to Tim, who does a lot of writing in terms of his arbitration decisions, and I'm going to have him explain what a typical week is like for him.
Okay, a typical week, there's no such thing in arbitration and mediation. We don't have typical weeks. Our weeks can turn on a dime because a case that you thought was going to go all day can settle in the first hour. So now what do, right? You suddenly find yourself with time, and normally we pivot to writing when that happens, because you got to get the writing done, and the writing has to be done on time, and the writing has to be as close to perfect as you can get it, because it's set in stone. You can't claw it back once the award is issued. So with that in mind, a typical week would be 5 days of hearing, starting at 7 o'clock in the morning, ending at 7 o'clock at night. So I would typically work 12-hour days, 200 days a year, because I'm still stuck in the 80s when the standard was 2,000 billable hours a year, and I just can't get that out of my head, because that's what you should be billing if you're a lawyer a year. That's how my brain still works. Things have changed. That's fine. I didn't grow up in that era. I grew up in the era where that was the expectation for lawyers who wanted to keep their jobs.
How many awards or decisions do you issue a year, Tim?
Somewhere between 56 and 75.
Mm-hmm. Sorry, and I interrupted you. Go ahead, please.
No, so writing is constant, right? I'm always writing. I'm constantly writing, but I'm constantly doing hearings. A typical week would be 1 or 2 days with hospitals in New York City in their cases. Then I will do a wage and hour case, and I will do an employment discrimination case, and then I will probably end the week with a commercial piece of commercial litigation or resolution. That's a typical week, and it's usually busy. Like I said, I work a lot, but I only work 200 days a year because I carve out 156 days for non-working days. So it's completely non-working days that I spend with my family and my grandkids.
Right, and we've been throwing around the term wage and hour. So wage and hour is unpaid wages or underpaid wages. Somebody may not be paid the minimum wage or the amount of the wage that they're due. They may not be paid overtime. They may not be paid correctly. They may not be paid timely. There's variations within all of that. And as Viviana said, that's about 10% of the federal court judges' dockets right now.
Yeah, it's a lot. And then we also do claims administration, which is another part of it, right? Because after these wage and hour cases get resolved, there's a need to get people paid. There's a need to send out notices and have those notices responded. That's a whole different process, but you have to think about that as your negotiation continue and you're mediating. You want to know what the class looks like and how complicated it is. Restaurants are really hard because these people are transient in terms of working. They don't stay at one place long. They got to find their last address. It's a lot of work. A lot of labor and employment is work. You work. This is not a field where you're going to make money if you're not ambitious about working. And the thing is, you got to love what you do, or you're not going to be good at it in labor. Yeah. This is really a people field. You have to be energized by the people and the work that you do.
With that, I'm going to turn it over to Jose, our union attorney. Can you give us what a typical week or month looks like for you?
Yeah, so I carry a caseload. And that caseload may include different types of cases and matters that we're working on, everything from a hearing to a legal memorandum that has to go out to the field. That may require me to be on the road, and being on the road for my office at least may include from Buffalo all the way to Long Island. But I think the core of our work and what takes up most of our time, of course, is preparing litigation, especially administrative hearings. And there's all these, and Tim can tell you, there's all this inner workings that go into kind of hearing preparation, because you have to select an arbitrator. That in and of itself is kind of an art. You have to meet with clients, you have to meet with witnesses, you have to kind of prepare your different examinations, your opening statements, stuff like that. So it's really time consuming. And of course, at the end of our hearings, we're clearly doing closing briefs, which can take a very long time to do, right? And as I mentioned before, we're also, we'll get a matter in from the field where something has come up, right? It could be contractual, it could be something under the education law, and then we have to, of course, research that matter and provide, put together a legal memorandum, which ultimately goes back out to the field to advise them on that specific issue. And a host of other administrative things. A lot of our cases, like Tim mentioned before, get settled, right? So we're also working through settlement agreements. I have about 2 or 3 settlement agreements right now that I'm working on. So that's typically what a snapshot of my week would look like. This week in particular, I'm just basically preparing litigation as I get ready for about 3 hearings that are coming up. One in the city, one up in Potsdam, and the other places in New York, which I think is a great part of my job, by the way, that I really enjoy. So I actually met Tim in a very remote area of New York State, so we're all over. But yeah.
Yeah, the fun part about practicing in our area is there's no 2 days that are the same. There's no 2 days that are the same. I get to visit each of the 62 counties in New York almost on an annual basis. I love going to these small little villages in upstate New York and meeting and doing collective bargaining in the basement of an old church or library somewhere. I mean, that you just can't put a price tag on. For people that really love that kind of stuff, that's the best day ever, driving up to Canton, New York, and meeting somewhere, and you've never been there before, but you might get the afternoon off to run over to the University of there at St. Lawrence and play around the golf. It's just a fabulous lifestyle.
Right, you've had both you and Jose have had the opportunity to travel throughout the state, and Tim, I would think nationally for you, certainly.
Oh yeah,
Tracy nationally and internationally.
Next week, I'm going to Hattiesburg, Mississippi. How would I ever get a chance to do that and have somebody actually pay for me to do that? I'll be in Hattiesburg. I've never been to Hattiesburg. I'm excited. I'm gonna go to Hattiesburg, Mississippi, 2 days to do a discharge case.
It's great.
Fabulous.
So I'm going to start again with Tracy. Is there some advice you would give to somebody who wanted to be a labor and employment lawyer, or who wanted to be an attorney, just about practicing in this field or practicing as a younger attorney?
First thing is kind of really, as you can see, there's a lot of variety under the heading, labor and employment attorney. And so I think trying to do things to explore what it is that you really kind of have a passion for doing is ultimately kind of incredibly helpful, right? And so do you, want to represent people like most of us do on this call, or do you not want to be in that situation? And do you want to do more of kind of the mediation and arbitration? And kind of I sit back and I'm sitting in the seat of being able to kind of judge what the parties do and kind of guide them to resolution. Do I want to work on behalf of the government in some capacity, and right, they're federal, state, and local agencies that help defend people's rights through that lens. Do I prefer to work kind of one-on-one with people? I mean, you know, to line and underscore and italicize and bold what you said earlier, and also Viviana, you know, there's a lot of psychology that you have to be able to deploy, particularly when you're dealing with individual folks. And so, again, I said I don't normally do this, but I have a special situation that I'm dealing with now. And I have to do with this individual client so much hand holding, right? So it's constant phone calls, it's constant emails, it's constant, does this matter? Does this fact alarm you? Does this fact concern you? And so there's just a lot of that work, which is a lot different than dealing with a corporation, right? Where I can go to in-house counsel and say, give me your policies, give me your procedures, give me the complaints that this person has done, and kind of work through things in not necessarily a more dispassionate fashion, but where I really don't necessarily have to do a lot of the hand-holding that I have to do with an individual client, where I feel like I'm part lawyer and part psychologist. And, you know, why do you want to perhaps be a defense attorney? And is that something that you can live with? Do you feel okay defending organizations where people say, you know, I was subject to this type of harassment, this type of discrimination? And, you know, would that rest right with my soul? I'll put one little kind of caveat there, right, which is what I generally find is that most companies do want to do right by their employees, and you might have a bad apple here or there that needs to be addressed. So I personally don't have kind of any view of this that I'm helping employers kind of get away with bad things. I usually find when you're thinking about an organization that there can be some bad apples, and the employers themselves want to deal with that. So I think all in all, it's really about finding out which lane you enjoy, what sits well with kind of how you like to operate, and then pursuing the day-to-day footsteps of a person who practices in that area. One last thing, you know, I think I read, like all of us do, in the papers, right, about all of these fancy, interesting, exciting M&A transactions. And I think, isn't it great? You know, Amazon and Whole Foods, wow, they're merging. And doesn't that sound very exciting and interesting? And I knew myself I could never be an M&A lawyer, even though it was interesting in thought, because I don't like the pens up and pens down nature of that. Kind of, I'm more cat-like. And so litigating is a good thing for me because I like to have a schedule. And so in addition to kind of thinking about what really interests you substantively and might I want to do, you've also got to think that you've got to live in the shoes of being that lawyer on a day in and day out basis. And so because I don't like negotiating with folks, and because I don't like the deals on, the deals off, that was something that I knew would just not sit right with my personality, even though I found it was interesting. So I think you just want to be exploring all of those things as you're thinking about L&E generally, and then kind of what type of L&E lawyer you want to be.
That's great, Tracy. Thank you. Viviana, your advice.
Yeah, I think, you know, thankfully I have, my firm, like I said, is very unique in that we do both sides. So I haven't had to pick that lane, but generally the more L&E lawyers you'll hear, most of them have, you know, drink the juice one way or the other. There really isn't much crossover. You'll see defense lawyers that would never, ever represent an employee or an individual. And then vice versa. Some plaintiffs lawyers would never work on a defense side for whatever reason. I am of the same opinion as Tracy that, you know, representing a company doesn't mean that you're letting them get away with anything. It's a very powerful position to be in. You're setting the policies from the top down. So you're really able to impact all the employees if you're able to give good advice and make sure that they're implementing and being compliant. So that's actually, I think, a very interesting part of labor and employment. If you do find a firm that lets you do both, lets you experiment into both. But I guess my advice would be that even if whichever lane you're in, one thing that I think is so important is writing skills, because writing is really a lot of what you do. Like 90% of my day is writing, whether or not that is for negotiation purposes or in a litigation. Advocacy is very important, but if you're not able to communicate effectively on paper, you're going to have a hard time. So in terms of law students that are looking into these things, if you like to write or you're not really sure, I encourage you to take more writing classes, take classes that do writing papers at the end, let somebody look over your writing, get feedback. It's just so important. It's something that you develop at our firm. We're not necessarily looking for folks that are so committed to labor and employment. Sometimes just like, are you smart and can you write? And do you have an interest in labor and employment? It can be taught. You can get that experience, you can get that litigation experience on the job, but whether or not, writing is just such a critical part of what you do. And I guess the other thing I would say is that if you're interested in labor and employment, it is such a small community in New York. You really do interact with the same folks. Somebody who had a case with 10 years ago, you will see them again. It might take another 10 years for them to come around, but especially people moving around, you're going to see the same folks. So one thing to keep in mind is, mentorship is so important. Really find somebody, join the bar associations, find a mentor within labor and employment, and they can really help guide you in your positions and what you decide to do, whichever lane you end up. And you might go back and forth between management and employee or, government work. It really, really depends. And, eventually you might transition into mediation and ADR. I've had a lot of colleagues that have done that after, we were saying 20 or so years, 15 years, you start to transition into that kind of style of practice as well. And I guess the only other thing I would just say is that as a younger attorney, just keep in mind, of course, that in labor and employment and in any field, really, just your reputation is so important. You just have to guard it fiercely, make sure that the way that you practice is true to yourself, and that you're not, adopting somebody else's style. Your name is so important. And attorneys talk, compare notes. Do you know this defense attorney? Do you know that plaintiff attorney? And if you are projecting yourself in a way that's not professional or difficult or whatever else, the word's going to get around. And so you really just want to make sure that your reputation is true to who you are, and it really in any field that you decide to pick. It's also in labor and employment, just because how small and tight knit it is. Everybody really does eventually come around to one another.
Yeah, and it's, I mean, our section, we sit down in Saratoga or in DC or wherever we have these meetings, and we all break bread together, despite the fact that we sit on opposite ends of the table or do different types of work. And I think being part of this section, I'm just going to tell one quick story, and then I'm going to turn it over to Tim and Jose. I had a case where we needed documents from somebody that had a relationship with the defendant. I represented the plaintiff, and they had enough of a relationship. They didn't necessarily want to give us the documents. And I spoke to their general counsel, and it was all very difficult. And then they hired outside counsel, and the outside counsel they hired was somebody I knew one of the named partners through this section, through sitting down and having a beer with him, and socializing with him and talking to him about what I did and what he did and all these other things. And being able to say that I knew this person and I knew this person through this section, it helped me get a level of professionalism that I wouldn't have gotten otherwise. And the battle didn't get any easier, but it got fairer and it got more courteous than it was going before I mentioned that I knew this guy through the section. It is a small community, it's a tight-knit community, and we give people an opportunity to be together in a way that's both professional and personal. I know a lot of things about people in our section from sitting down with them at dinner. It's great. I'm going to turn it over to Tim, our past president of our section. Go ahead, Tim.
I just echo what everyone has said. I mean, what I hope they're taking down what Tracy has said, what Viviana has said, what Jose has said. Is exactly what my notes reflect as well. But overall, first of all, no one becomes successful on their own. You need the help of other people along the way. That's the most important thing. And I've been truly blessed to be surrounded by some of the most elite talent that our field has ever created. I mean, when I was a young lawyer, I tried to work with the best lawyers I could find. I was able to work with David Boies. I was able to work with Milton Gould. I was able to work with Bill Shea. Then I was able to work with Dick Rowley and Ron Dunn, the former chair of our section as well, and Mark Walsh and Bernard Ash. And now I work with Marty Scheinman. And so I think surrounding yourself with the best talent you know in your field is an excellent way to go about living your life. You know, if you can, if you're fortunate enough, find your people. Find your people. Find the people that celebrate you. Find the people that have a shared interest with you. Find people that aren't afraid to speak your name in a room full of opportunities. All right? That's what you're looking for if you're going to build a wonderful career in labor and employment. All of us can focus on core competencies, right? We know how to read, we know how to do, but do we know how to be, right? Are we practicing at the highest level? Are we scaffolding up? Are we staying, up to date with the law? That's what the state bar is for, right? We have wonderful CLE programs that I've always loved because they kept me current. They kept me on the razor's edge of what was going on in the profession. That's what's important. It's also important to know how we got there. Keep the same 5 books on your desk, a Curie and a Curie, the 7 tests of just cause, the CPLR, know it inside and out, public sector labor law. Keep those books on your desk, read them. Read because they mean something different when you're a young attorney versus at 20 years in. The same sentence will read completely different once you have experience in the field.
Well, this came up when we were preparing for this section. I went to a state bar event and I saw the author of Because of Sex, which is it's a book where they give the personal stories. Tim is going to go get the book right now, and I can do it in my office. They give the personal stories of 10 litigants in Supreme Court discrimination cases, their stories related to the cases. It's a deeply personal experience of what you read about on a piece of paper. And it's an incredible book that whatever side of whatever issue you sit on, it's just good to have it so humanized. Tim has it in his office. I have it over here in my office. I've given it to people who don't even practice law, but I got it at a state bar event. I got a chance to hear the author speak.
Yeah, me too. That's where I got it.
We were there together. We
were there together in this revolution, because that's what labor is about: real people in real life in their lives. Because work is essential, and we learned that through COVID, the essential nature of work. It's so important to people's who they are as individuals, and so all these statutes, the Fair Labor Standards Act, the Taylor Law, whatever the Civil Rights Act of '64. Yeah, read about it. Learn about the Heart of Atlanta and what happens to real people and why these laws came to be, because there's a human being at the heart of every story in labor. There's a real person attached to those stories and to those statutes. When you terminate people, it's heartbreaking because it's devastating to that person, to that family. But if management proves its case, they deserve to get the result they want. Right. Just like in contract cases, they're really hard cases. Thousands of people are going to be affected by this. But if the union proves its case, hey, they're entitled to the language they want at the bargaining table. And so these are real gut-wrenching decisions. There's usually a winner and a loser. It's so rich in this field. You can move from Jose's chair to Tracy's chair. You don't have, just because you started in labor working for a union doesn't mean you can't migrate later on to management and vice versa. We all are in the same big pond, but we don't swim in the same areas all the time. It's a wonderful, wonderful area of law. I'm just so grateful that through a process of elimination, I found it. I tried everything else, but this is what I loved.
Thank you. I don't want to cut off another human being, which is Jose, but I also don't want to cut off people who have been great about attending this, who may have questions. I don't see any questions in the chat. box. Tracy has to leave in 5 minutes. Tim in a half an hour. I'll stick around for a half an hour. I also see in the boxes that we've got Lauren Gazinski, our present chair. I think we've got Abby Levy, who's going to be our chair-elect after Lauren. She was here earlier. The people in the audience are great. You're wonderful students in the sense that you have your microphones muted. Can I turn it over to questions? Would someone want to put a question in the box or just raise their hand or unmute themselves and ask? You've got a great group here, and I'm sure you've got questions for us. Even Lauren could come up with a question. Come on, Lauren.
I'll just come up with a comment, and Tracy, I apologize if I'm echoing you, but for some reason your audio didn't come through as well as everybody else on the panel to me where I am today. But just great information, everybody, and just kind of echoing on the passion thing and the people aspect. What I go back to is whatever is hot button in society at any moment. That's what we're dealing with day to day. And I mean, literally, like, for example, when those secret recordings of Justice Alito and Justice Roberts came out, A, I wasn't surprised. Anybody paying attention knew. But B, I had been dealing with, I had just done a presentation for PLI on discrimination against, on the basis of sexual orientation and gender identity. And essentially right now there's a growing conflict between claims of religious freedom and religious accommodation, and in particular the LGBTQ plus community. That's just one example of how what we do every day is exactly what, if you're a concerned citizen and you have empathy and you pay attention to life, when you're talking with your friends and family about those things, we're dealing with them because they come into the workplace.
Thank you. Well put, Lauren. We have a couple of questions that popped into the box, and Tracy, if you need to jump, please do. Is there a particular area of labor law where there is a need for additional attorneys to practice? I've got some thoughts, but I'll turn it over to you guys first.
Well, I mean, I think you look at there's ton of organized workplaces across the state. Indeed, private sector unions are, I think, hovering around a little under 10%, but you still have public sector labor that is above 30%. So there's all these different labor organizations representing employers throughout the state. I just don't see that changing anytime soon. There's always going to be a need for labor lawyers, and I can say that because I see the job postings, right? So so just from a basic kind of common sense perspective, where the numbers aren't going to go down anytime soon with the number of organized labor, but what corroborates that is the different postings and the different, of course, labor organizations looking for lawyers.
Tim, Viviana?
I would just say that there's, like Jose said, there's always a need for labor lawyers, and there's always a need for employment lawyers too, in terms of the more like discrimination, harassment, more traditional areas of discrimination law. And then, wage and hour, like I said, there's a lot of cases out there that are filed. The laws just keep getting more and more, I say, like, complicated. There's more and more regulations coming out. It's constantly changing due to the administration. So I just don't see wage and hour going away anytime soon. And that can be like for me, a private practice, but you could also work with like the Department of Labor, either the United States Department of Labor, the New York Department of Labor. There are a lot of folks calling up that need assistance, and whether that be through the agencies or like the Department of Labor, I think that that's also a good avenue to go down for labor employment that I don't think is going away anytime soon.
Yeah.
Okay. There's a change in my industry in arbitration and mediation that's caused by just the way labor is set up. I told you at the beginning that most panels require that you have at least 20 years of experience. The average age of a labor arbitrator, a decision maker in a labor arbitration case, is 74 years old. You understand that? 74. So I can't help you if you're just starting out, really, because you've got to do that 20-year bid, right? You got to do those 20 years. And I would recommend that you go somewhere where you're actually doing collective bargaining, administrative hearings, and court proceedings. You don't want to go to a place where you're managing a war room, where you're doing document production and digesting and indexing of documents and that kind of stuff, because that's not the skill set you need to be an arbitrator and mediator. To be an arbitrator and mediator, you actually need to be doing collective bargaining, administrative hearings, and court proceedings. You cannot be in your office all day. Do not take a job where the people are in their offices all day. Okay? Don't do that. Find a job where the people that you are looking for are always gone. All right. That's all I can tell you. If you catch me in my office, I've screwed up when I was a labor lawyer. I need to be in the field. I need to be doing things. I need to be with my clients at the table, in administrative hearings, in court. I need to keep my briefcase in my car, not in my office.
Well put. Someone's asking, if a practicing attorney wanted to make a transition to labor and employment, what would the panel suggest to make the attorney more appealing to a firm doing labor and employment? And I've heard a couple people on the panel opine, and I think it's my opinion too. I mean, you need basic lawyering skills, not just labor and employment law skills, but being able to question about a work environment, asking the right questions, knowing how to question, knowing how to write is essential in our field. But is there any sense of what transitioning lawyers into our field might do to make themselves more attractive to us? Anybody?
I would just say general litigation experience, I think, is very helpful, whether that be at a firm, not necessarily doing labor and employment, but just getting familiarized with court appearances and just the different mechanics of litigation. And that could also be working for a judge, I think, is also very helpful. I did that during law school, and I thought it was an invaluable experience. You also are exposed to different types of law if you're not really sure, but because labor and employment is so often litigated, I did get to see a good amount of labor and employment cases called before the judge. So that was very interesting for me, seeing it from the other perspective. And I think I think firms are, that's appealing to a firm, whether or not that you've got that experience. And also, of course, that goes in with the writing, because when you're with the judge, you're doing a lot of writing.
Yeah, I would also keep in mind that, there is overlap, right? So, in our practice, yeah, I'm not sure if it's typical, but it comes up, right? So right now I'm working on a wage, a minimum wage issue, right? There may be another case where we're working on a discrimination matter. So there is some overlap that I think you can take with you. And I think Tracy may have alluded to this, is you got to be hungry to kind of take on the different cases and to let your managers know that, hey, what is that? No, I've never done that. I'll take it, right? So there is going to be some overlap, but as Viviana also said, though, is along the way you're preparing yourself just by litigating matters and doing the depositions and interviewing clients and stuff like that. And one of the advices that I was planning to give was, don't ever stop doing professional development the last day you practice law. Don't ever give up on that, and be very kind of diverse about it, right? Just prepare yourself for all sorts of kind of moments and cases and matters that come up.
Tim, do you want to add anything, or should I move on to the next couple questions?
It's fine to move on. I think it's fine.
So I'm going to ask your thoughts on this also. I'm going to mash the two questions remaining together, but is there anywhere that they can find, people can find open positions for labor and employment jobs in the New York State bar site, It doesn't seem to have many listings anywhere else where someone might look. I know because my firm's posted on through the New York State Bar, there's a weekly email that goes out with open positions to be hired. We've used that in the past. I don't know what resources there are at the New York City Bar anymore. I don't know, and I don't know whether Viviana can speak to it as to resources that might be available through NELA. NELA is the National Employment Lawyers Association, which is lawyers whose practice primarily is representing employees. So there may be resources there. And anybody else in terms of resources?
I think if you're interested in working with specific labor organizations, you can certainly go straight to their websites. There's also other internet sites such as the Union Jobs Clearinghouse if your preference is to work with labor organizations. But you'll see a lot of labor and employment jobs also coming up on your typical platforms like Indeed and stuff like that. But since we're on that topic, I think this is one of the reasons why I think it's important to really kind of, participate with labor and employment with NYSBA. I think there are people that can make a direct connection to where they are today in their careers and kind of their relationship with NYSBA and the relationships that they've created. So that's one strong source that you really want to tap into.
Do you want to tell that story about the when you were applying at NYSET? Are you comfortable talking about that, or?
Well, it kind of involves Tim, so I don't know if he's comfortable about it. He may not know, but so I met Tim, like I said, at an arbitration, and he got me kind of re-involved, if you will, in NYSBA and with the executive committee. And when I applied to NYSET, I put that on my resume that I was part of NYSBA, and my manager, I didn't put Tim down as a reference, but my manager knew Tim, and she contacted him directly without me knowing about it. But that's just, Viviana was talking about this being a small world. So, you create these relationships, and, in this case, at least it worked out to my benefit, right? So that's just the way it is, right? And I've also been part of the mentorship program, which to me was absolutely, I thought it made an impact on my career. So
in the past, this section has had a mentoring program linking younger lawyers with experienced lawyers. Jose was a beneficiary of that program. We're trying to reinstate that. And I'm going to piggyback on what Jose said too. One of the things I didn't mention about his credentials is he's a committee chairperson, co-chair of the Workplace Rights and Responsibilities Committee of this section. They're meeting on Monday. The committees are a great resource to get to know labor and employment lawyers and also to talk substantively about what's going on. At that meeting, new cases or new developments in labor and employment law will be spoken about on Monday. Come to our meetings, come to the fall meeting. You're going to be with 200 labor and employment lawyers. You're going to shake a lot of people's hands, and some of them may be looking for an associate or may have a connection that can help you further down the road.
I would just echo that. Networking is really important, but people use that word in a way where you're just kind of, shaking hands and having small talk. That doesn't develop connective tissue in labor, right? What does it in labor is service, right? That's what turns people that work in labor employment. We're about service, right? So if you want to get to know us, you have to work with us, whether you're management or labor or neutral. The first thing, it's almost like that John F. Kennedy thing, ask not what your country can do for you, but ask what you could do for your country. That's labor. When you come to our meetings, don't expect people to be doing things for you. Expect to be asked what you are going to be doing for the organization, for the betterment of our field. It's about service. So when I met Jose, I met Jose first at a bar association of that. right? And then I had met him at an arbitration. He was willing to serve. He asked, what could he do for the organization, right? Why? And I said, we need you. He said, what can I do? That's how it works in labor. I'm unsure of other fields, but service is a very key component. Don't come to our meetings expecting people to serve you.
Right, if you have knowledge in an area, present on it, present as part of a CLE panel.
Exactly.
Meeting and talk about it. I'm reaching out to new members as chairman of the Membership and Engagement Committee. And the question I ask them is, what do you want us to do for you? And what can you do for us? It's a two-way street. It really is.
Steve, if I may, just off of what Tim was just saying, just yesterday afternoon and evening, I was at an Association of Corporate Counsel, which is an in-house group meeting where I was presenting, and it was the Women's Global Law Symposium, and Carla Harris, who I don't know if you can see the book, but was speaking there. And to Tim's point about I don't know outside of this field, I think it's outside of this field too. I mean, she's an investment banker at JP Morgan Chase. She's on the board of the world's largest company. And she described it as there are kind of two kinds of capital that matter in your career. There's performance capital and there's relationship capital. And if you think about what Tim was saying, you need to prove the performance, and work is part of it. And then the relationship capital, it isn't just small talk. Relationships actually exist when you manage to create a back and forth. You do something for somebody else. You show care and empathy and interest in somebody else, and you get them to do the same for you. And it doesn't feel transactional, like just giver and taker. It actually feels like a flow of back and forth. If you really want to get into advance in our field, you need to have excellent performance capital, and you need to develop excellent relationship capital.
I agree with that completely. And I think our field in our section, you guys mentioned earlier, is that people do move within our community. And one of our colleagues was sort of a general practitioner in labor and employment, has moved essentially to being in-house only with management, but also has a mediation and arbitration practice. He's part of the panel in the Southern District. But, you know, in addition to just chatting with him at events, he was my mediator in a case. And when he's approached for work that he turns down, he thinks of me, I think partially because of the way I presented to him. You know, you have to be able to walk the walk and talk the talk. And you really do have to participate. People who've presented as part of CLEs in front of us, I've referred work to if it's work that I don't do, because I know that they know what they're doing because of the way they present. It's a very exceptional forum, I think, that we provide people. And all of you have presented at our CLEs. Everybody on the panel today. Well, I'm not sure with Viviana. I know your partners have, but we'll get you. We'll get you.
Yeah, they have. And I think what we're talking about, you know, networking, you know, these speaking engagements are so helpful. The conferences, really just putting yourself out there, getting out of your comfort zone, getting out of the office. That's really where you meet people, the, you know, local bar associations, and sometimes not even labor and employment associations, just business associations. There you'll meet attorneys that are doing other types of law that will say, hey, I don't have a labor and employment attorney that I know well, or, you know, what kind of cases do you do? You know, professional groups also, we were talking about NELA. NELA has a great plaintiffs listserv, plaintiff's attorney listserv that is constantly in motion. I don't join it because I do the defense enough that I wouldn't qualify, but I know a lot about it. I know a lot of information is shared on there, also regarding like job opportunities and just how are you dealing with this case, and this type of what new equipment are you using to download social media off of somebody's phones, things like that, things just like the practical tips and tools that you need as a litigator. You can get it from these kinds of colleagues that you'll meet just along their career. And like I said, people that you meet 10 years ago, you'll see them again for sure.
Absolutely. If there's more questions, we're happy to answer them. If anybody wants to unmute themselves and talk informally with us, we're also happy to do that. I think otherwise we can just end this program unless anybody else has any questions or anything else that you want. I would encourage you, please, to try to come to our events, join our committees. I'll post my information real quick in the chat room. Hang on for 1 sec if I can do that.
And if anybody wants to learn more about how to become an arbitrator or mediator, you can reach out to me. Just Google my name or send me an email. You'll get that information. We run programming for newer arbitrators a lot through the Scheinman Arbitration Mediation Service and also through Cornell. So if anybody really wants to have a career and you don't know really how to line it up, just reach out. I'll give you some tips on how to set yourself up for a career in arbitration and mediation.
Yeah, and our section, I mean, I did mention every fall we have these meetings. 3 of the 4 years are typically in New York. We've gone to DC, we've gone to Toronto, we've gone to Montreal. We've had the Supreme Court, the Chief Justice of the Canadian Supreme Court present to us in Montreal. I'm going to show a picture in a sec. When we were down in DC, we got a chance to have an informal meeting with Justice Ginsburg at the US Supreme Court. Here's a picture of our group there. I mean, it's just a great opportunity. I cannot find my screen share. Oh, boy.
To be the green button on the
Oh, gotcha. Here we go. But this is us, and in the middle, in the nice shawl, is Justice Ginsburg. This is at a courtyard in the Supreme Court. She just made remarks to us that were typical of some of the speeches that she was doing at that time. It was a really wonderful opportunity for a lot of people in our section. And we've had Second Circuit court judges, US District Court judges, magistrate judges present to us, professors from Fordham, professors from RPI present to us in the human resources field and in the employment law field. It's just a great way to keep yourself current with it. I'm going to end this meeting now unless anybody else has anything else. And I thank you all very much for our time. Please stay or be involved. Anything I can do for you in terms of membership and engagement, please reach out to us. The State Bar's resources lists all our committees. It lists people you can contact in our programming. Please come and join us. Thank you all.
Thank you so much, Steve, for putting this together.
Good. Take care, everybody. Lauren, take care. We'll see you soon.